You are listening to Based in Fact, a true crime podcast. Join host Lisa O'Brien and Kyle Evans as they examine America's most infamous true crime cases as they were established in our courts and the basis for the decisions of the appeals courts, not the court of public opinion. Here's Lisa and Kyle.
Welcome to Season 4 of Based in Fact, a true crime podcast. We're your hosts, Lisa O'Brien and Kyle Evans, and this is Episode 7, State of Florida versus Ashley McArthur. McArthur, a former crime scene investigator, was convicted in 2019 of the September 8, 2017 murder of her friend Taylor Wright, a private investigator and former police officer. Taylor was involved in a contentious divorce and mistakenly trusted McArthur to hold money Taylor withdrew from a joint account. Unfortunately for Taylor, McArthur spent Taylor's money the moment she got it. McArthur decided to kill Taylor to cover up that theft. We'll talk about Taylor's disappearance, McArthur's thefts from Taylor and others, and the case against McArthur, including her trial and direct appeal. And good afternoon, Kyle. How are you?
I'm doing well. How are you, Lisa? This is, as I said before, this looks kind of like a saucy one.
Yeah, a little bit.
A little bit
Uh,
more days of our lives than some of the other ones we
yeah.
covered.
Well, the funny thing is, well, no, it's actually because it's just about greed. It's not
Yeah, I guess I'm
about,
thinking all the other stuff around it.
it's not about, although that may come into play later on, but we'll see. Um, excuse me. So I do have a couple program notes though. First of all, John Hanson, the Oklahoma prisoner who the federal government refused to transfer to state custody in 2022. He was transferred to Oklahoma and has been executed for the murder of Mary Bowles that he committed in 1999. Dalia DiPolito's federal habeas case has been dismissed. And so far, she has not filed anything at the 11th Circuit Court of Appeal to appeal that. So her federal habeas may be done. And Rodney Reed has, the Fifth Circuit has denied his DNA challenge, and he is now appealing that to the U.S. Supreme Court.
It's a shame more of our tax dollars spent on Rodney Reed's defense.
Yeah. And Richard Glossop, I believe, a retrial on murder charges. So those are a few program notes, and we'll probably do an update. We may even do an update for the beginning of next season, before the end of this season, because there are a few things, happening and going on. But I just wanted to start off with those few things, kind of a 6-month check-in.
Got it. Nice
so to speak.
stuff.
All right. So in this case, the victim is Taylor Ashley Turcotte Wright. She was born April 24th, 1984. Unfortunately, there's not a lot of information available about Taylor online. Most of it, or all of it, really comes from coverage of the murder case. So, but I believe her father is Randall Turcotte. Her mother is Linda Turcotte. I don't know if she has any siblings from her birth parents. Her adoptive mother is Nancy Murchison. Basically, when Taylor was a young teenager, she began living with Miss Murchison and her family. Again, I don't know whether she has siblings with their Turcotte family, but I believe she has 2 adoptive brothers, John and Daniel, and one adoptive sister, Elizabeth, with Nancy Murchison's family. She did graduate from high school. She was a criminal justice major in college in North Carolina. I don't know whether it was North Carolina. I don't think that it was Duke, but it could have been Duke because those are the two big North Carolina schools, or it could have been another North Carolina school.
Yeah, in NC State or something.
Yeah. And I don't know whether she graduated or not. It's not clear. Um, and she was a police officer in Jacksonville, North Carolina from 2008 to 2013. She also was a private investigator in Florida. She married Jeffrey David Wright around 2005. They divorced in 2015, and she had a son, Drake, born in 2010, and her injury cause of death were gunshot wound to the head, or was gunshot wound to the head. The perpetrator is Ashley Ritchie Britt Nix McArthur. She was born August 22nd, 1977 in Gulf Breeze, Florida. Her parents were John Ratliff Britt, who died September 10th, 2021, and Rhonda Ritchie Britt. She has no siblings. She has a high school diploma, and she graduated college with a criminal justice degree. She was a former and that was around 2006, 2007. She also, for a very brief time, was the CEO of an amusement company started by her parents called Pensacola Automatic Amusements.
What
And
did they do? Like video games
they
or
they rented
clowns?
out they rented out pool tables, video games, and jukeboxes
Gotcha.
to local lounges and game rooms, although there are fewer and fewer great game rooms now. With the with phones, we don't need an Xbox necessarily
Right.
when we're on vacation. So but they rent those out to businesses. She was married first to Philip Christopher Nix Sr. They divorced in 2012. And then Zachary Vernon McArthur. They were married around 2014 and they divorced in 2019. She has a daughter, Savannah K. Nix. There was an effort to change Savannah's last name to McArthur, but it appears that did not happen. Emotional mental, she is definitely a sociopath. She's a liar and she's a thief. Her prior crimes include 2 counts of grand theft, fraud, and arson, and her victim was Taylor Ashley Turcott Wright, who was 33 years old. This crime occurred on September 8th, 2017 at 2201 Britt Road, Cantonment, Florida, and that's in Escambia County in the Pensacola area.
So kind of in the panhandle. Or in the panhandle.
Florida Panhandle. But it's like literally a stone's throw to Mobile, Alabama.
Right there in
And a little
the
bit bigger
redneck
stone's
Riviera.
throw to Mississippi, Gulf
Right.
Coast. So people go to Alabama. It's a short trip. I think maybe 30, 40 minutes at the most. And within an hour, you can be in on the Mississippi Gulf Coast. So it's very close. Taylor's early life wasn't easy. We don't know much, but we do know that by the age of 13, she'd been taken in by Nancy Murchison and her children. Taylor finished high school and went on to college in North Carolina, and that's where she met excellent mother, and Drake was her pride and joy. In 2013, Jeff was stationed in Florida and the family moved to Navarre in Santa Rosa County. By 2015, they'd settled in Okaloosa County. By their 10th anniversary, the relationship between Jeff and Taylor was fractured. Each claimed that the other requested a divorce at their anniversary dinner. On June 16, 2015, Jeff filed the petition for dissolution in Okaloosa County. Subsequent events show that Taylor was hurt and angry. One bone of contention was a personal injury settlement that was being treated as community property by the courts. Custody of Drake was another issue. During a heated confrontation with Jeff, he called police and Taylor was arrested, which ended any hopes of Taylor returning to her law enforcement career.
So does she think that Jeff just wanted a divorce because he didn't want to split the personal injury settlement?
No. What happened with the personal injury settlement is that Taylor made the mistake when she got the settlement of commingling it in a joint account that she held with Jeff. And I think it was like a joint investment account. If she had put it into a separate investment account in her name only, it would have remained 100% hers. But once she put it into the community, it became part of the community. The only thing that she could have done was when she got it and put it in the community account was to get Jeff to say, I understand that this is 100% her money and I'm not entitled to any of it. But she would have had to get a signed document from Jeff. Saying it's not, I don't have any right or entitlement to it, or just keep it separate. And I would suggest in any marital relationship, whether it's the husband or the wife, that if you have a personal damage settlement, personal injury settlement, an inheritance, significant or not, put that into an account in your name only. And then if you want to take some of it and share it with the community, you can do that. But the best way to protect it, and I learned this the hard way, because I commingled an inheritance with my joint account with my ex-husband. And so when he used my inheritance to pay off his personal debts and did not pay off my vehicle like he was supposed to, I had no recourse because I had commingled the funds. And it bit him in the ass, because when we split up, he called me and said, oh, by the way, you need to start making your car payments again. And then he was confronted with the fact that he was supposed to pay the car off and didn't. And my attorney used that as leverage and was actually able to get him to go ahead and take out a loan to pay the car off. But she said if he doesn't kind of decide to do this on his own, there's not much we're going to be able to do to make him do it. But she did use it as leverage because he was supposed to have paid my car off. I mean, that was like the first thing he was supposed to pay off. But his reasoning was, well, that was the lowest interest rate we had. So what he did was for 18 months, 2 years, he just made the car payments, and I thought my car was paid off. So, but yeah, so she had commingled it, and that was her error when she got the funds.
Gotcha.
But again, that's not how it played in her head, because I'm sure she probably told her attorney many times, he knows that's my money. He knows that's mine, So, by early 2017, Taylor had relocated to Pensacola, where she was working as a private investigator. Around Memorial Day, she met Cassandra Waller, and they began dating. Soon, they began an exclusive relationship, although there were bumps when Taylor admitted to a relationship with another woman in Biloxi, Mississippi, and to trying cocaine. For 2 years, Taylor and Jeff engaged in a contentious divorce and child custody fight. In the end, Taylor lost custody of Drake, and she was ordered to pay child support. The court order also permitted Jeff and Drake to move back to North Carolina. Finally, the order provided for a 50-50 distribution of the couple's bank accounts. Taylor wasn't happy with this decision because one of those accounts held a $100,000 personal injury settlement that belonged to Taylor. When things were good with Jeff, she deposited that money into a joint investment account with him. Her attorney filed a notice of appeal to challenge the court's order, but Taylor took matters into her own hands, and on July 12, 2017, she withdrew $100,000 she considered to be hers from the bank. Taylor put the money into several cashier's checks and gave some of it to friends for safekeeping. Now, and as it turns out, she may not have given that to multiple people. She may have only given that money to Ashley McArthur, who was a failed crime scene technician who was running an amusement company started by her parents. By contract, the company was supposed to share all proceeds earned by jukeboxes placed in local bars with the owners of those bars. McArthur violated the contracts by refusing to pay the bar owners their full share. When McArthur tallied the jukebox earnings, she kept all the money earned through debit and credit card payments and only paid a share of the cash profits. She would ultimately be arrested and charged with grand theft and fraud in connection with those thefts. On August 16, 2017, McArthur was arrested on a grand theft charge arising from her failure to send garnished child support payments from an employee's checks to the state of Florida. In an interview with investigators, she claimed that the employee stole the support checks from the mail. She also failed or refused to provide payroll records requested by investigators. On September 6, 2017, a no prosecution statement was filed by the state attorney. But I think this may have contributed to Ashley's decision that murdering Taylor, spoiler alert, was the way to go. Because she had just been through this grand theft allegation and arrest.
Yeah, so
And
she's got a
potentially
history
facing
of being
charges.
dishonest. You know what?
Yeah. By early September, Taylor and Cass had decided to move in together, and Taylor had packed her things and begun the process of moving into Cass's house. Taylor was also facing contempt proceedings as a result of her impulsive decision to take her settlement money from the joint account. Taylor was reconsidering her rash decision and trying to get the money back. She'd been texting McArthur to arrange to go to the bank and retrieve Taylor's money. Taylor didn't know that in addition to stealing from her customers, McArthur had stolen every penny of Taylor's money. And this was probably close to $100,000. And the way Ashley did this was actually first by saying, "Oh, I have a friend at this bank, and she'll let you put these things in an empty safe deposit box."
Well, it's
at
funny.
the
That
bank.
was my first thought. I was like, why didn't she just get a safe deposit box?
She wouldn't want to get a safe deposit box in her name because the court and or Jeff could
Uh,
find it.
so she's really she's
She
trying to
was
hide the money that
she
she
was
thinks
trying
is
to hide
rightfully
it.
hers. But
She was trying to hide it. She believed it was hers. But by September 7th, when she was facing contempt proceedings, she was trying to get the money back, to put it back in the account, and to let the appeal run its course. But Ashley had made the decision to kill her already. So on September 6, 2017, Taylor requested a continuance of a hearing scheduled for September 7th. She also had plans to go to the bank with McArthur, who never showed up that day. At dinner that night, Taylor stressed the importance of getting that money back into the bank to avoid being jailed for contempt at the next court date on September 12, 2017. She and McArthur made plans to go to the bank on September 8th, 2017. McArthur did show up at around 10 a.m. on September 8th. Cass and Taylor communicated by text through the morning. After a cryptic text in the late morning, Taylor stopped responding to Cass's texts or answering her calls. Later that afternoon, Cass texted McArthur, who called Cass at around 4 p.m. McArthur claimed that Taylor was stressed and that they'd gone to a farm in Milton, Florida, owned by McArthur's family. When Cass asked to speak to Taylor, McArthur claimed she was riding a horse and promised to have her call when she finished riding. Taylor didn't call and missed plans with Cass for dinner. Worry became frustration. Cass's texts became accusatory, and Taylor seemed to be ignoring them. At 8 p.m., Cass received a text purportedly from Taylor that read, "I'll call you later. I'm not angry with you, and I should have called, but I just needed to think I'm trying to get my life organized and on track." Later that night, McArthur told Cass that Taylor left in an Uber between 5 and 5:15 p.m. to go downtown for a drink. Cass was hurt, and her trust issues with Taylor led to an angry text telling Taylor not to bother coming back. On September 10th, 2017, Cass made a missing persons report. The report wasn't pursued because Taylor was an adult and free to leave if she chose to leave. On September 14th, Cass's second report was taken more seriously. Initially, she was the prime suspect, but her statements were complete and honest, and investigators soon eliminated her as a suspect. McArthur's statements to police contained lie after lie after lie. McArthur voluntarily gave police her cell phone, but claimed not to know the passcode for the phone, which slowed their investigation but didn't stop it. Investigators soon found that there was no record of any taxi or Uber pickups at or near McArthur's address on Raintree Drive, and that Taylor's Uber account hadn't been used in about 2 years. Cell tower location data retrieved from Taylor's phone revealed that Taylor's phone was at Ashley's house on September 9th, 2017, and was in Alabama while McArthur and her husband attended a family wedding. Bank records demonstrated that Taylor's money was transferred and spent by McArthur within days of it being deposited. Phone data and vehicle GPS data revealed that McArthur and Taylor were never in Milton on September 8, 2017, and that they were in Cantonment. When questioned by police, McArthur claimed not to know the address of the property in Cantonment and promised to provide information that was never forthcoming. On their own, investigators identified the property at 2201 Britt Road in Cantonment. And remember, she claimed not to know the address, but the name of the road is her family name, her maiden name, Britt. On October 19, 2017, investigators executed a search warrant at the property. While that search was going on, investigators were in their final interrogation with McArthur. For the first time, she claimed that Taylor had buried a lockbox on the Cantonment property. After a couple of hours, she invoked and was allowed to leave. After several hours, a wildlife agent stumbled across Taylor's body along a fence line. She'd been buried in a shallow grave covered with potting soil and concrete. McArthur was arrested shortly after Taylor's body was found.
Jeez.
So, that's just, it's just horrible.
Yeah, so
And
unnecessary.
and she lied, she did so many lies. It's like, how can you possibly believe that anybody's going to think you're innocent?
Right.
Because
That's
lying is basically knowledge, consciousness of guilt, especially when you don't tell them, when you tell them, oh yeah, I don't know the address, but I'll get it for you, and you never do. And then the
right.
address turns out to be the name of the road is your freaking family name. Not to mention the fact that she'd been out there before. She had kept a horse out there. It was like she had ties to that property. So first of all, the grand theft was in the Circuit Court of First Judicial Circuit in and for Escambia County. The docket number was 2017 CF 4521. The judge was the Honorable E.P. Nickinson III. It was grand theft, $300, but less than $500. There was a fire at Pensacola Automatic Amusements on June 8th, 2017. The warrant was May 22nd, sorry. In an email on June 30th, the DA requested that the warrant be reactivated. Apparently, Ashley was arrested on August 16th by the Escambia Sheriff's Office, and then the state elected not to prosecute her on September 6, 2017. More likely than not, because she was claiming the employee stole the checks out of the mail that she was trying to mail, and they hadn't been able to get any of the financial records, and then the financial records no longer existed. because of the fire at the company. And
But she
that
definitely
fire,
set, right?
pardon?
She definitely set that fire.
She was acquitted of those charges.
Ah.
Just to, yeah. But I'm gonna say circumstantially, she's the most likely suspect. Missing person homicide investigation. A search warrant was issued for the Britt Road property in Cantonment on October 18th. A search warrant was also issued for property on Raintree Drive that was where McArthur and her husband Zach and daughter Savannah lived. And then also a warrant was issued on the same date for 2414 North Pace Boulevard in Pensacola, which was the Pensacola automatic amusement property, and it was where Taylor's belongings were being stored, because Cass was hurt and angry and frustrated when it seemed like Taylor had just taken off. And so and Jeff Wright didn't help matters, because he gave Cass impression that Taylor was potentially dangerous, even though I don't think that was true. I think Jeff was just out to trash Taylor for whatever reason, much like her murderer did. Then Ashley McArthur was arrested on the 19th by Pensacola Police Department. A warrant was issued for murder, dangerous, depraved, without premeditation. That's a second-degree murder charge, because they didn't have enough information at the time to go with first degree, but it was put down as no bond. They also issued search warrants on October 20th for the silver Ford F-250 truck that Ashley and Taylor left in on September 8th. Ashley made her first appearance on October 20th, 2017, and her bond was set at $1 million. She waived arraignment on October 27th and entered a not guilty plea. Her counsel at the time was David B. Ackerman, and Andrew S. McGrave and Bridget M. Jensen represented the state. A second search of the Raintree property was conducted by a search warrant issued on October 24th. October 31st, search warrants were issued for a white Apple iPhone and a black Apple iPhone. A search warrant was also issued on October 31st for a white Samsung tablet, and for computers, desktop, laptops, notebooks, USB drives, hard drives, SD cards, and DVR devices at the Raintree, probably seized from the Raintree property address. An order granting a verified stipulation for substitution of counsel was entered on November 2nd, and that substituted John and Barry Barossett, father and son team, and withdrew Ackerman as McArthur's attorneys. McArthur was also charged with grand theft, fraud, and arson in the Circuit Court of the First Judicial Circuit in Escambia County, docket number 2017 CF 6123. The judge in that case was the Honorable Jan Shackelford. A warrant was issued for her arrest on the grand theft and fraud charges on November 6, 2017. She was arrested by the Escambia County Sheriff's Office, possibly still in custody at that time. A preliminary probable cause determination was made on November 8th, and her bond was set at $50,000 on count 1 and $50,000 on count 2. Criminal information was filed on November 6th, charging her with racketeering, organized fraud, and arson. She pled not guilty on November 15th, 2017, and John C. Barossett was substituted as her counsel on November 29th, 2017. In the murder case, the case went to grand jury on November 7th, 2017. She was indicted on that date for first-degree premeditated murder. On November 8th, another search warrant was issued for Ashley McArthur's black Jeep Wrangler. In the racketeering fraud case, a subsequent First Amended information was filed on March 7, 2018, on the racketeering, organized fraud, and arson charges. And I couldn't really tell, looking at the amended informations, whether there was a substantial difference or not. They may have developed additional facts that they added to the information that just didn't jump out at me. Then an order granting a motion for statement of particulars was filed or was entered on September 11th, ordering the state attorney to provide additional details and particulars regarding the alleged theft from Seville Quarter. A statement of particulars was filed on October 15th, 2018, setting forth the amounts due to the owners of Seville Quarter and Azalea Lounge. Amended statement of particulars was also filed on October 18th, with additional information about the amounts due to the Seville Quarter and Azalea Lounge. The second amended information was filed on January 18th, 2019. McArthur went to trial on January 22nd, 2019. Jury selection was held. Her trial began the 23rd through the 25th. And the verdict was entered on January 25th, 2019. She was found guilty of racketeering and organized fraud, but not guilty of arson. Her sentencing was held on the 21st of February. She was sentenced on the 25th. Or the order of judgment and sentence was entered on the 25th, sentencing her to 84 months on count 1 with credit for 121 days, 3 years probation, 100 hours community service work, 5-hour minimum per month, and to complete all hours over the first 20 months of supervision, and then 5 years on count 2 with credit for 121 days and $518 mandatory felony court cost. And the court reserved jurisdiction for 90 days to determine restitution. Restitution was ordered in that case, but the orders are not available. The notices of the amounts are not available to view online. But she was ordered to pay restitution to Seville Quarter and Azalea Lounge. She filed a notice of appeal on February 27, 2019. The statement of judicial acts to be reviewed were the court's denial of Ashley McArthur's motion for judgment of acquittal, sufficiency of the evidence challenge, and the judgment and sentence entered on February 21st, 2019. John Barasset moved to withdraw, and that was granted, and the public defender was appointed for the purposes of appeal on March 4th, 2019. Now we get to the murder charge.
That seems like I mean, I'm no softy on crime, but that's a pretty steep sentence. I mean, I know she stole money, but it was less than 25,000. That's 7 years, 10 years in prison. That's a pretty steep penalty for.
Well, I disagree, because I don't believe that the penalty should be determined by the amount of money stolen.
Yeah, I guess that's fair.
I think whether you steal $1 or $100,000, it's not what you stole or how much you stole, but the fact that you stole it.
Well, and she did continue to keep doing it.
And it went on for 2 years, I believe. So, and the worst thing is, I think that this essentially ran that business into the ground.
The arcade business?
Yeah. That her parents had run for 25 years. And she takes it over for, 2 years. And it's worthless. It's worth nothing.
Yeah.
And it goes out of business. I mean, it still exists in the Florida Secretary of State, but I doubt that it's a very viable, successful business anymore. I could be wrong, though. I mean, if Ashley's mom wants to call me and tell me otherwise.
According to Yelp, it is closed.
Ah, okay. See? All right. See,
It looks like smart. They tried to make I don't know, maybe they always had it, but it looked like they tried to have a little bar in there too, but
Yeah. All right. So the murder case is in the Circuit Court of the First Judicial Circuit in for Escambia County. Docket number is 2017 CF 5844. The judges were the Honorable Thomas Danaheiser, the Honorable Jenny Kinsey, who recused herself, and then finally the Honorable Jan Shackelford. And having watched the trial, I like Judge Shackelford. She's received some criticism, but we'll talk about that a little bit later. And I'll tell you why I totally disagree with the criticisms.
Sorry,
You're
I hate to
all
interrupt, but
dying
I
to
was
know.
looking. Apparently, Ashley Britt also has an active LinkedIn profile.
Oh, does she?
Yes. Sorry, it's just pretty funny that.
Pensacola.
Yeah,
Does she list herself
Pensacola
as
manager
CEO?
of Pensacola Automatic Amusements,
Yeah.
and then something
Well,
called Purely Southern. I don't know what that is, but it's pretty
yeah,
funny.
that was another company that she had that didn't really factor in too much. All right, so her counsel were Barry W. Barosset, the father, and John C. Barosset, the son. The state attorneys were Andrew S. McGrave and Bridget M. Jensen in the pretrial process. Um, on January 8, 2018, McArthur filed a motion to set reasonable conditions of pretrial release. And in her grounds, she cited substantial ties to the community, not a flight risk, and the court has discretion to grant or deny bail. We know from Dahlia DiPolito that Florida does not like to keep people in prison or in jail pre-trial or even after conviction when their case is on appeal. So Florida has very easy pre-trial release criteria. Judge Jenny Kinsey recused herself on January 16, 2018. The case was reassigned to Judge Shackelford. A hearing was held on the motion to set bail conditions on February 1st, 2018, and that was granted. On February 2nd, 2018, it's ordered and adjudged that the defendant's motion to set reasonable conditions of pretrial release is hereby granted. The specific conditions of defendant's pretrial release were articulated by the court at the bond hearing and are unchanged by this order. Her bond was reduced to $500,000, which is still a lot of money, but she comes from a wealthy family in Pensacola. Her pretrial release was approved on February 7th, 2018. She was required to make a weekly report to pretrial services beginning on February 14th. She could not possess drugs or consume alcohol. She was to agree to random drug and alcohol testing. She could not possess firearms. She would reside with her mother in Gulf Breeze, Florida. She was confined to Escambia and Santa Rosa counties, and she was to have no contact with state witnesses, including David, Kyle, and Carla Britt, who were her uncle, aunt, and cousin. There was a notice of restitution filed by the state on February 27th seeking $1,325 due to the Crimes Compensation Trust Fund, which McArthur objected to. The state filed a motion to revoke bond on April 16, 2018, alleging that McArthur had violated her conditions of release when she stayed with her husband at 3961 Raintree Drive from April 3rd, 2017 to April 4th, 2017, when she's supposed to be in Gulf Breeze and she's supposed to have a 10 p.m. curfew. She filed an objection to the state's motion to revoke bond and request for hearing on the same date. And she basically offered hearsay statements from pretrial release officer and GPS officer claiming that she was following the terms and conditions of her release. And apparently there was a neighbor at either Raintree or her mother's who took issue with her being free on bail. And Apparently, Ashley McArthur, if you watch the court TV trial, she sits there with wide eyes and no expression on her face, which is what makes me say she's a sociopath. And she just doesn't seem to understand the consequences of her actions or what she's facing, in my opinion. And so she's on pretrial release and she's swanning around sunbathing on the front yard.
Yeah, well, I think a lot of people
mean-
do. I think a lot of people, defendants, don't. They don't understand really. Like they almost like live in denial.
Yeah. And I mean, you know, if she wants to sunbathe, do it in the backyard. Don't do it on the front yard where the whole neighborhood can frickin' see you, because it looks like you're, you know, being an obnoxious asshole.
Right.
And you know, they're gonna take issue with that, honey. And this is a case, a lot of stuff is available online. Her trial's available on Court TV, which includes all of her interviews with Pensacola police. And the videos are also available on YouTube. I would suggest anybody that has an interest in this case, go watch those videos. Because watching her lie to the police in all of those interviews and hearing her lie to the police and the way she trashed Taylor's reputation in her statements to police, it just, again, so sociopathic. Taylor had no value to her once she got all her money. We don't know the exact amount, but we know Taylor had had converted the money to cashier's checks. And we know there were maybe 2 or 3 that ended up in Ashley McArthur's accounts that didn't appear to have been signed by Taylor. So the exact amount is unknown. I think there's one $34,000 cashier's check that is undisputed, but the rest is it was probably close to $80,000, $81,000.
Wow.
Yeah. And the fact that Ashley McArthur pissed all of that away in record time by buying stuff for her boyfriend because she was in an open marriage. Or she claims she was in an open marriage. Maybe she really wasn't. I don't know.
Oh, she was okay. So her boyfriend, in addition to the husband.
Yes. Yeah, he ran
And
one of the.
she and Ash, or she and Taylor, were they lovers?
No.
Okay.
No. She alleges that Taylor suggested a threesome with a guy. But no. But yeah, there was a guy at a pool hall that she frequented, and
The guy or the pool hall?
the guy, well, probably both. I mean, you know, after she finished playing pool, you know, she played with somebody else's stick. But she bought him a boat, she bought him a motorcycle, she paid bills for his business, for his bar.
I mean, I don't mean to be flippant. It's just,
Uh,
I mean, it's bad. It's horrible, but it's like, I mean, you have a little sympathy if you're like, okay, she stole the money to like help her family's business stay afloat, but it just makes it so much worse in white trash. It's perfect Florida that she stole all this money and killed this poor girl to buy her boyfriend while she's married, boats and motorcycles. I'm shocked there's not jet skis.
Yeah. Well, he probably didn't ask for a jet ski. All right. So the hearing on the motion to revoke bond was held on April 23rd, 2018. And bond conditions were addressed at that hearing, although I don't know how Judge Shackelford addressed them. But again, you know, I repeat, Florida has very easy pretrial release standards. And you remember Dahlia DiPolito did not get permission to travel to Miami and appear on 2020 and walk around her attorney's office with Amy Roebuck, but she did it. and then the judge did not penalize her for that.
All right.
But she got a little slap on the wrist for doing it, you know. And she was also able to get pregnant while on pretrial release and have a baby while on pretrial release. So, the state on May 1st, 2018, filed a second motion for a notice of restitution seeking $2,400 for the cost of the investigation into Taylor Wright's disappearance. That was also objected to by McArthur. And then on the 24th of July, they filed a third notice of restitution seeking $23,675 for loss of support for Taylor's son, Drake. On November 2nd, 2018, McArthur received permission to travel to UAB Birmingham for a donor evaluation on November 5th, 2018, and she was ordered to keep pretrial release advised of the schedule and to report on November 6th, 2018. She basically was being evaluated to potentially donate a kidney to either an Escambia County Sheriff deputy or a Pensacola police officer who had been severely injured and who needed a kidney transplant. And it doesn't look like she turned out to be a match because nothing ever happened after that evaluation was done. And a lot of people were unhappy about that too. And you know, I think she was doing it because it would look good.
Well, that's what I was like. It's so random when she's on trial, about to be on trial for murder. But I guess you're right. Just kind of a publicity stunt.
Right. So on February 25th, 2019, the court entered an order denying defendant's motion to suppress. The court has benefit of a video recording of the defendant's waiver for Miranda rights. This video supports the conclusion that defendant's decision to waive her rights under Miranda was the product of free and the defendant herself is a former law enforcement officer. There's no evidence that the defendant had any difficulty whatsoever understanding the Miranda rights when they were read to her. Moreover, the defendant nodded her head to express her understanding and signed a written form acknowledging her waiver of Miranda rights. The defendant's understanding of a right to an attorney is demonstrated by her invoking that very right later in the course of the interrogation. Accordingly, it is ordered and adjudged that defendant's motion to suppress is hereby denied. And this was seeking to suppress the October 19th statements that she made during the interview while police were busting all of her lies as a search was going on at the Britt Road property that she had no idea that they knew about at that point. A search warrant was issued on July 10th, 2019 for the data extracted from McArthur's cell phone. Then on July 22nd, 2019, an order was issued on her motion to suppress that information. Therefore, the court finds there was probable cause for affidavit and search warrant number 1, and any technical defect was cured by affidavit and search warrant number 2. Ordered and adjudged that the defendant's motion to suppress cell information is denied. And she was alleging that the initial cell phone did not say it was her cell phone or identify her as the account holder. It only identified the phone number. And then the second search warrant that was issued identified her as the account holder and as her cell phone. On August 8, 2019, an order denying defendant's motion in limine was entered, ordered and adjudged that the court finds that the motion in limine should be denied as to conversations in the presence of defendant Ashley McArthur at the Twin Peaks restaurant. That's the September 7th dinner. Text messages between Taylor Wright and defendant Ashley McArthur between August 29, 2017 and September 6, 2019, and text messages between Taylor Wright and Cassandra Waller. They had objected on the basis that all those things were hearsay. Then we moved to the murder trial, which remained in the same jurisdiction, venue, same docket number, same judge. Counsel for the state was Bridget M. Jensen. Counsel for the accused were Barry Barosset, the father, and John Barosset, the son. And that was the other really cute thing at the trial. The judge would say, Mr. Barry was held on August 26, 2019. The guilt innocence phase was August 26, 2019 to August 30th. And I believe this was a 12-person jury. You remember in Florida, for some charges, it's a 6-person jury. But this, because this is first degree premeditated murder, it was a 12-person. Now, I don't understand why the state wouldn't have gone for the death penalty.
Right. At least to get it. Yeah.
But they didn't. And from what I can tell in the record, they never even considered it. And that may be Escambia may not be a county that pursues the death penalty. Again, the trial is available on Court TV. It's very interesting. It's very quick because there's, it was only 4 days. They don't show the jury selection process. They just show the opening through verdict and sentencing. But it's very interesting, and it really is worth a watch. On August 30th, 2019, after 2 hours of deliberation, the jury came back with a guilty verdict, first-degree premeditated murder with a firearm.
That may be one of the fastest murder convictions I've ever heard.
Yeah. I think I've heard of a couple faster. I think I've heard of a couple that were like under 30 minutes.
Wow.
So, and this was an entirely circumstantial case, don't get me wrong, but the circumstances are exceptionally strong. McArthur is the last person seen with Taylor Wright. Taylor Wright is seen leaving with Ashley McArthur on September 8th, 2017. Nobody sees her after that. Her phone was where Ashley McArthur was on the 9th, either at the Raintree property or in Alabama. She lied to police. I mean, everything she said was a lie. She tried to hide where they went to misdirect the investigation. And her attorneys didn't like it, but those are exceptionally strong circumstances that even without physical evidence to corroborate them. I mean, there's video of her buying potting soil and concrete at a Home Depot near the Britt Road property. Because once they found Britt Road, they found additional evidence. So there are strong circumstances. So on August 30th, 2019, she was committed to the custody of DOC. An order of judgment and sentence was entered on September 3rd, 2019. She was sentenced to life on count 1 with credit for 327 days, concurrent with her other sentences on the grand theft and racketeering. Firearm enhancement of 25-year minimum and $518 mandatory felony court cost. Her attorneys moved for acquittal at the end of the state's case and then at the end of the state's rebuttal, and that was denied. They filed a written motion for judgment of acquittal on September 6th, 2019, and that was, they alleged they failed to prove that Ashley McArthur killed Taylor Wright and that Ashley McArthur did so through a premeditated design, and that the evidence of premeditated murder, even viewed in the light most favorable to the state, failed to exclude every reasonable hypothesis of innocence, as the case is based almost entirely on circumstantial evidence. It's funny, though, because they didn't really cite any hypotheses of innocence. They also filed a motion for a new trial on the same date, saying the verdict was contrary to the law and weight of the evidence, that the court erred in denying her motion to suppress her cell phone location information. The court erred in denying the motion to suppress her statement taken on October 19, 2017. The court erred in denying the motion to suppress hearsay statements. The court erred in admitting testimony and photographs regarding a .38 revolver that belonged to defendant's father, because the state was not able to tie the firearm photograph and testimony to the offense. That the court erred in failing to grant the defendant's motions for judgment of acquittal at the conclusion of the state's case in chief. That the court erred in failing to grant the motion for judgment of acquittal at the conclusion of all evidence, and that the court erred in failing to grant a mistrial when a photograph of defendant pointing a shotgun at the person taking the photograph was displayed to the jury, and that the court erred in denying the motion for mistrial as a result of that and the display of that photograph. Basically, after in rebuttal, the state put detectives on and went through some of the pictures they'd found on Ashley McArthur's cell phone of her scuba diving, on a whitewater rafting. They alleged she had back problems that would have prevented her from being able to move Taylor's body or carry the concrete or hide Taylor's body. And so they were going through, and during that time, a photo that had been ruled to be inadmissible by the judge was accidentally displayed for a second, and then it was taken down. So the judge gave a cautioning instruction, and the jury were ordered to disregard that. An order denying the motion for new trial was entered on September 12th, and the same date, an order denying the motion for judgment of acquittal were also entered. The state filed a motion to modify the judgment and sentence to include restitution on September 17th. The state's motion to modify was granted on September 19th, and the court reserved jurisdiction to determine the amount of restitution. A notice of appeal was filed by McArthur on the 19th of September. The statement of judicial acts to be reviewed were the trial court's denial of defendant Ashley McArthur's motion for judgment of acquittal at the close of the case in chief and at the close of all evidence on August 30th. The trial court denial of the motion for judgment acquittal on September 12th. The denial of the motion for new trial on September 12th. The denial of the motion to suppress attorney-client interview hearing held on December 18, 2018. The trial court's denial of the defendant's motion to suppress statements held on February 20th, 2019. The trial court's denial of the defendant's motion to suppress cell phone information held on June 25th, 2019. The trial court's denial of the defendant's motion for mistrial made during the course of the trial the week of August 26th to August 30th. The sufficiency of the evidence and the judgment since entered on September 3rd. An order granting motion to withdraw and appoint a public defender for appeal was entered on the 23rd of September, and that withdrew the Barosets and appointed the public defender to represent Ashley McArthur on appeal. Counsel on appeal was Bradley Harrington Rowe. An amended notice of appeal was filed on September 26, 2019. The amended statement of judicial acts to be reviewed was the December 18th criminal pleas in motion to suppress attorney-client interview, the criminal pleas in motion to suppress statements, and then each phase of the June 25th evidentiary hearing on the motion to suppress cell phone information, a motion in limine held on July 31st, and then the entire jury selection and jury trial. The direct appeal on her racketeering and fraud case was at the First District Court of Appeal, and that docket number was 1D 2019-858. Her attorneys were Jessica J. Yeary and Barbara Boucharis. Her notice of appeal was filed on March 6, 2019. The case disposition by opinion was entered on January 14, 2021, and her conviction and sentence were affirmed per curiam. The mandate issued on February 5th, 2021, and her conviction and sentence became final on that date because she did not file a petition for a review to the Florida Supreme Court or a petition to the U.S. Supreme Court. And it may become final after the expiration of the time to file those. So it may be later, final, but I put it as final. When you don't file, I put it as final on the date it was issued. I could be wrong, though. Her direct appeal on the murder charge was at the First District Court of Appeal. That's docket number 1D 2019-3491. The attorneys are Michael Offerman and Barbara Boucharis. The court granted an order seeking to supplement the record on appeal, requesting a copy of the June 25th hearing as to why Brandon Beatty should not be held in contempt for failure to appear for deposition on June 19, 2018, or June 19, 2019. And then the motions on all the motion and orders issued in connection with that proceeding. Order on motion to withdraw as counsel was entered on February 16, 2020, withdrawing the Second Judicial Circuit Public Defender and noting Michael Offerman's appearance. A notice of pending motion to correct sentencing error was filed by the state on March 5th, 2020, and an amended order of judgment and sentence were issued by the trial court on March 11th, 2020, noting that McArthur had been found guilty as charged and had adjudicated her guilty as count 1, first-degree premeditated murder with a firearm. And I believe there was an error that it didn't, the original judgment and sentence didn't say she went to trial. So they had to correct that. And that was also, there's another order entered on March 13th, 2020 to correct that, to amend, to reflect that she proceeded to trial. The record was supplemented on March 16th, 2020, and on March to grant a mistrial due to the inadvertent display of the hunting photo, a photo of McArthur crouching in hunting gear and pointing a shotgun, not the murder weapon, accidentally flashed on the screen during trial and was before the jury for a second or two. After an objection, the court addressed the issue quickly by giving a cautionary instruction that was requested by the defense. Meanwhile, other trial testimony had noted that McArthur owned firearms, that there were photos and evidence of her in camouflage holding or shouldering firearms. Taking these factors together, the trial court's decision that the photo wasn't so prejudicial as to vitiate the entire trial cannot be considered erroneous. As the statements McArthur made after waiving her Miranda rights, the trial court correctly found that the state met its burden of proving that McArthur had waived her rights. A defendant may waive so-called Miranda rights, but only if the defendant is informed of those rights and the waiver is made voluntarily, knowingly, and intelligently. This is not a case where Miranda warnings were minimized or improperly administered so as to lull McArthur into not paying attention to her rights. Let's see. In fact, McArthur, who had previously studied criminal justice in college and had worked in the sheriff's office as a crime scene technician, indeed exercised her Miranda rights by seeking a lawyer about an hour into this interrogation. McArthur claims that the application in this case deficiently listed only a cell phone number without detailing that the number was the appellant's number. When read as a whole, however, the application makes clear that the affidavit is referring to McArthur and her cell phone. We find no error here. McArthur's final argument relates to the victim's text messages and statements that she believes were inadmissible hearsay. But this evidence was not offered to prove the truth of the matters asserted, but was relevant to establishing a timeline, motive, and intent. The trial court did not abuse its discretion by allowing those into evidence or by failing to give a limiting instruction explaining why this evidence was offered. The judgment and sentence are affirmed. Rowe and Long, JJ concur, but they didn't issue a concurring opinion. The mandate issued on May 7th, 2021. Then McArthur did file a notice to invoke discretionary jurisdiction of the Florida Supreme Court on May 17th, 2021. An order issued on May 27th, 2021, granting an extension of time to July 1st, 2021. On the 1st of July, a second motion for extension was granted to allow petitioner until July 12th, 2021 to file her brief on jurisdiction. The initial jurisdictional brief and appendix were filed on and then issues independent of the issue on which jurisdiction is invoked included the trial court erred by denying her motion for mistrial after the prosecutor displayed an extremely prejudicial picture depicting petitioner pointing a shotgun. The trial court erred by denying petitioner McArthur's motion to suppress cell phone information, and the trial court erred by allowing the state to introduce hearsay statements, text messages, and statements to Cassandra Waller. Alternatively, that the court erred by failing to give a limiting instruction that the text messages and statements were not being introduced for the truth of the matter asserted. And basically, she argued that the first district's decision expressly construed the privilege against self-incrimination. Respondent's jurisdictional brief, their argument made on July 26, 2021 was that the petitioner did not argue in the trial court or first district for specific construction of Article 1, Section 9 of the Florida Constitution or the Fifth Amendment of the United States Constitution. Moreover, the first district did not expressly construe either provision. Rather, the first district applied the relevant case law in issuing its opinion. Based upon well-established precedent, such action does not constitute expressly construing a provision either of the Florida or federal constitutions. As a result, this court does not have jurisdiction to hear a petitioner's case. The disposition was issued on August 19, 2021. This cause heretofore having been submitted to the court on jurisdictional briefs and portions of the record deemed necessary to reflect jurisdiction under Article 5, Section 3B, Florida Constitution, and the court having determined that it should decline to accept jurisdiction, it is ordered that petition for review is denied. No motion for rehearing will be entertained by the court, and that's according to Florida Rule of Appellate Procedure 9.330 D2. Stipulated civil restitution lien orders were entered on September 15, 2021, and McArthur was ordered to pay $1,325 to the Bureau of Victim Compensation on behalf of the victim. That's probably funeral expenses. $23,675 to the Bureau of Victim Compensation for the loss of support by Drake, and $2,400 to the Escambia County Sheriff's Office for the cost of the investigation. A writ to the United States Supreme Court was filed on November 18, 2021, under docket number 21-6405. The question presented was whether a law enforcement officer's minimization, downplaying of a defendant's rights set forth in Miranda versus Arizona renders a subsequent waiver of those rights involuntary. The reason for granting the writ was that the Fifth Amendment to the Constitution protects against self-incrimination. This Fifth Amendment protection also provides the right to counsel at custodial interrogations. It is well settled that when an individual is taken into custody and subjected to questioning, she must be advised of these rights, i.e. the right to remain silent and the right to the presence of an attorney during questioning. As explained below, in the instant case, law enforcement officers minimized and downplayed the significance of the petitioner's Miranda rights, thereby rendering her subsequent waiver of those rights involuntary. The case was conferenced on January 22nd, 2022, and the petition was denied on January 24th. McArthur then went to the First District Court of Appeal under docket number 1D 2023-0183. Her counsel were Elizabeth J. Fryer, William Ponnell, and Laura L. Saparo, and she was challenging the effective assistance of her appellate counsel. Florida, if you have a problem with your direct appeal counsel, that goes before the District Court of Appeal, separate from your other state post-conviction claims. She filed a petition alleging ineffective assistance of appellate counsel on January 24th, 2023. She alleged ineffective assistance of appellate counsel in violation of the United States and Florida constitutions. Pardon?
I'd say always the ineffective counsel. It's just so token.
Yeah. By failing to raise several meritorious issues, ineffective assistance, and failing to argue that the trial court erred in precluding defense counsel from eliciting testimony regarding defendant's reputation in the community for peacefulness. And this is why she's a sociopath. Because she can kill somebody and within hours be around people and act like nothing's wrong.
Right.
Like say nothing happened, like just a normal day. Ineffective assistance of appellate counsel and failing to argue that the trial court erred in denying her judgment of acquittal, and cumulative effect of the errors in this case deprived defendant of a fair trial and requires reversal of her convictions and sentences. She requested an opinion vacating the judgment and sentence and remanding the case for a new trial, an opinion reducing defendant's conviction to manslaughter and remanding the case for resentencing, an opinion permitting defendant to file a new notice of appeal and proceed with a new appeal on the issues discussed in the petition, and such other further relief as this court deems just and proper. On April 24th, 2024, a per curiam opinion was issued. Having considered the affirmance of all three grounds in the petition, the court finds the petition to be facially without merit. The claim was dismissed. B.L. Thomas and Judge Tannenbaum concur, and Bilbrey J. concurred in the result. He wrote a concurring opinion. He said the result of the majority's decision dismissing the petition is that petitioner will not have her sentence vacated and the matter remanded for a new trial. I agree with that result, but arrive at it differently than the majority. The petition for ineffective assistance of appellate counsel complies with the pleading requirements of Rule 9.141D, Florida Rules of Appellate Procedure. The petition sets forth a prima facie basis for relief. That is, the petition is legally sufficient in its pleading to allege grounds for relief if true. And I'm not going to cite the case law. So we then examine the merits of the allegations and look at the record from the trial and subsequent direct appeal to determine whether we should grant relief. Since the petition here is facially valid in that it alleges two bases for relief, but it is without merit, since when we look into the record, appellate counsel on the direct appeal was not ineffective, I would deny rather than dismiss the petition. And then she goes to state post-conviction, back to the trial court, First Judicial Circuit, Circuit Court for the First Judicial Circuit in Forest Gambia County, and that's 2017 CF 5844. The judge is now the Honorable John Simon. William Pennell and Lisa Beth Fryer are still representing her. She filed her initial motion for post-conviction relief and incorporated memorandum of law. And these are basically the claims that she has raised. Newly discovered evidence that an alternate suspect, Brandon Beatty, made incriminating statements confessing to the murder of Taylor Wright. Ineffective assistance of trial counsel for failing to investigate Brandon Beatty as an alternative suspect and to thoroughly cross-examine him at trial. Failing to investigate relevant witnesses and by using a private investigator who had a conflict of interest. Failing to investigate and develop other suspects, including Zach McArthur and James Hayes. Failing to retain and call an expert witness on handwriting. Failing to retain and call an expert witness to testify about defendant's back injury and physical capabilities. Failing to retain and call an expert witness on concrete. failing to properly argue that the pool hall community was sufficiently broad to support the admission of testimony regarding Miss McArthur's reputation in the community
The
for
pool hall
peacefulness.
community. That's not something I've heard before.
You know, and those are not a group of people that I would consider to be necessarily peaceful.
No, not necessarily.
No offense to people who play pool, but the pool halls that I have hung out with are not always the most peaceful places because there are alcohol and there are easily available weapons. So, and maybe in comparison to that, maybe she is really peaceful. But again, I think that peacefulness comes from being a sociopath. So she can be mad as hell at you, but she's going to smile in your face
Right.
and hug you to feel around for where she needs to put the knife when she stabs you in the back. Failing to argue with sufficient specificity that defendant was entitled to a judgment of acquittal, and again arguing the cumulative effect of the errors at trial counsel in this case required the defendant be provided with post-conviction relief. There was a notice of filing on March 7, 2025, where she filed Exhibit A were prior criminal records of Brandon Beatty, and Exhibit B were post-trial criminal reports regarding Brandon Beatty. Now, the allegation that Brandon Beatty confessed is actually, it's a double hearsay statement that somebody claims somebody told her that Brandon Beatty confessed. But the problem for Ashley McArthur in prevailing on this point is that Brandon Beatty testified under oath at trial. He's never been to the Britt Road property. So how can he dispose of Taylor Wright's body on the Britt Road property without ever having been there? And he had no key. There was apparently a gate and you needed a key or a code. He didn't have that. He's not the one that was seen going off with Taylor Wright. Ashley McArthur, who was with Taylor Wright, never said, well, Brandon Beatty came by and they were having an affair, so I left her with Brandon Beatty. So you need to talk to Brandon. I mean, that might have bought her a lot more time had she told that story. The same with Zach McArthur and James Hayes. She's the last person seen with Taylor Wright. And while Zach McArthur probably could have gone to the property, there's no evidence that he did. And again, she never said anything about Zach McArthur, coming in, and she left Taylor with Zach or James Hayes, who worked for her at Pensacola Amusements. Okay, so in our last 10 minutes, because I know you have a hard stop at 5, but thank you for accommodating my
of course.
slow day today. We do have a few things, kind of ancillary proceedings to look at. We have the estate of Taylor Ashley Wright, and that was filed in the First Judicial Circuit, Escambia County, 2017-CP-001396. A petition for administration was filed by Nancy Murchison initially on November 16, 2017. Jeff Wright objected to that on January 3rd, 2018. The death certificate was issued on January 3rd, 2018. Taylor's Turcotte family relatives filed a waiver and consent on the same date. So I think maybe they were aligned with Jeff Wright. That was Randall Turcotte, her father, Ronald Turcotte, and Joan Huskins. Joan Huskins is an aunt. I'm not sure whether Ronald's an uncle. He could be a brother. It's unclear. Letters of administration were issued on April 12, 2018, appointing Jeffrey Wright as the personal representative of the estate. A petition to close the estate was filed on September 9th, 2020, and an order administratively closing the estate was issued on October 23rd, 2020. Then Zachary McArthur versus Ashley Britt McArthur was filed in the Escambia County, 2019 DR 003194. McArthur filed a petition for dissolution on August 3rd. Ashley McArthur answered on August 21st. A financial affidavit was filed by Zach McArthur on September 19th. A marital settlement agreement was entered on September 25th, and a final judgment was entered on October 1st, 2019, dissolving the marriage. And then finally, we have Wright versus McArthur et al. That was also filed in Escambia County Civil Division. I forgot to get the number. Oh, wait, I have it. 2019 no, I'm sorry. Yeah, 2019 CA 1459 Division J. Jeffrey David Wright as personal representative of the estate of Taylor Ashley Wright versus Ashley Britt McArthur. Carl D. Britt as trustee of the C.K. Britt Trust, and Kara J. Britt as trustee for the C.K. Britt Trust. They alleged negligence against Ashley Britt McArthur, battery against Ashley Britt McArthur, negligence against the trustees of the C.K. Britt Trust, which owns the property at Britt Road, and negligent entrustment by John R. Britt. They're suing for loss of support and services, loss of parental companionship, instruction and guidance in mental pain and suffering, loss of prospective net accumulations and medical or funeral expenses as a result of Taylor Wright's wrongful death. The complaint was amended on September 7, 2019 to add John R. Britt as a defendant. A settlement proposal was made to Wright by John R. Britt on March 6, 2020, offering $5,000 to settle any and all claims, including costs, interest, and attorney's fees. Second amended complaint was filed on November 3rd, 2020, and that some counts had been dismissed, so they filed new counts. Dangerous instrumentality doctrine against John R. Britt, because it's claimed that John R. Britt, the gun used to kill Taylor was John R. Britt's, but unfortunately they were never able to prove that gun is the one that killed. It's consistent with the projectile recovered, but so much time had gone by that they were unable to say one way or the other whether the gun was the one used in Taylor's murder. And then negligence against Britt regarding the gun, battery against Ashley McArthur, negligent entrustment.
So they're basically trying to blame the husband for...
No, they're trying to bring in her parents, her father and mother, and her
just
aunt
because
and
they
uncle
happen
who
to
own
have
the
a
property.
gun.
And they a notice of voluntary dismissal was entered on March 8, 2021, dismissing the C.K. Britt Trust due to an amicable settlement. So I think they did get some kind of settlement from the Britt Trust. But then an order granting John R. Britt's motion to dismiss counts 2, 3, 5, and 6 of the second amended complaint was entered on August 10th, 2021. They amended the second amended complaint, but I don't know what they did. And then John R. Britt died on September 10th, 2021. A notice of suggestion of death was filed. An order granting the motion to substitute parties, substituting Britt's succession representative as state representative. A motion for summary judgment was filed on July 9th, 2024. A hearing was held on October 9th, and an order was issued granting summary judgment on the 5th of November. And basically, you know, he had no claims, no causes of action to pursue against John Britt or Rhonda Britt.
Yeah, it seems kind of frivolous.
Frivolous. They were trying because Ashley is judgment proof. She's in prison for life. Now, she stands to inherit from her father's estate, so maybe they might get something, but it's going to be a long time. An order denying the motion for reconsideration was filed on November 8th. He appealed to the First District Court of Appeal, but that ended up being dismissed because he failed to respond to the court's order, show cause order. And then a judgment was entered for attorney's fees and costs by John Britt's representative, March 26, 2025. So now he has to pay $55,000 in attorney fees and costs. There was a hearing set on a motion for entry of judgment, and that was canceled. Case management conference was set for April 11, 2025. On April 11th to be held on May 15th at 11:30 a.m. Nothing has happened since then. Nothing's been filed. Ashley Britt McArthur remains incarcerated in the Florida Department of Correction. She's at Lowell with Dahlia DiPolito and Dee Dee Moore. So that must be fun.
Sounds like a fun party group. Probably having some wild nights.
And it looks like, I don't know if she has a projected release date. Let's see.
Maybe they'll get married. Maybe they'll get married while they're in prison.
Well, Dahlia's going to be out in 2030, I think. Somewhere around there, 2032. Let me see if there's a release. I believe she's life without parole, but okay, let's see. Does she have a projected release date? Nope, she's sentenced to life. So she gonna do life. So she and Dee Dee Moore are gonna be there for the long haul. You still here, Kyle?
Oh, still here. Well, good for them.
All right. So that's it. If you want to go ahead and hop off, because I know you have a hard stop, and then I'm just going to close this out.
All right. Sounds good. Have a wonderful week. We'll talk to you soon.
Thank you so much, Kyle. Talk to you later.
All right. Bye-bye.
Bye. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and Kyle Evans. If you like the show and want to know more, you can subscribe to our YouTube channel, find us on Facebook, or follow me on Twitter at O'BrienLN. Kyle and I will return in 2 weeks for episode 8, State of Delaware versus Thomas J. Capano. On June 27, 1996, Anne Marie Fahey, the scheduling secretary for Governor Thomas Carper, went to dinner with Thomas J. Capano, a local attorney and the son of a prominent real estate developer in Wilmington, Delaware, my dad's hometown. This was the last time anyone saw Anne Marie alive. In 1997, Capano's brother Jerry admitted that he'd helped his brother dump Anne Marie's body in the Atlantic Ocean. We'll talk about the case against Capano, his trial, direct appeal, and post-conviction claims, including the commutation of his death sentence and his death on September 19th, 2011. Until then, have a great 2 weeks and stay safe.